Hello, and welcome to another episode of Ask Two Lawyers. I'm Keith Davidson.
And I'm Stewart Albertson.
And you've got questions, we've got answers. It's Friday, it's 1 o'clock, and it's time to answer some questions. But before we get to that, I just want to take a little bit of time to say hello to the guy who's in our hearts and in our headphones, producer Eric. How's it going?
Oh, hey, I know where you were going with that.
You didn't know you were in our
misdirection. Yeah,
I'm doing great. You know you're in our headphones. You didn't know you were in our hearts.
Yeah, that's true.
Okay.
Yeah, I'm doing good. I'm in the Christmas spirit, so.
Oh, excellent.
Yeah.
That doesn't really sound like you're in the Christmas spirit, but I'm going to take your word for it.
Yeah.
Okay, great. And of course, Stuart's coming to us from Knoxville, Tennessee, where he's out at the Cirrus Training Center learning to fly jet airplanes. The new Cirrus jet. How's it going out there, Stuart, with the training?
You know, I'm very tired today, but I didn't want to miss this. We've consistently been making these 1 o'clocks on Friday, so I wanted to be here. I'm enjoying the training, but it's been a lot of work.
Yeah, I can imagine so. That's a big step up. So I can't wait to see the end result. You've got another, what, half a week?
Yeah, I'll be hopefully done by next Wednesday.
All right. And hopefully we can come to everybody next week from the studio and answer your questions. So why don't we see what we have on tap for today, Eric?
Yeah, so we'll start with some of the questions that we've gathered from listeners all across our channels of social media and YouTube. We'll start with this question here. A listener writes in and says, is it legal for a trustee to sell a subtrust? Sell in parentheses or in quotation marks. I believe my attorney and the trustee/lawyer are negotiating a price for the subtrust that names my granddaughter, who is 9 years old.
So I don't know that I fully understand the question because you don't typically sell trusts. You can sell assets inside of a trust. Sometimes there's a lot of negotiation about what assets are going to go into a trust. Maybe we should start by just explaining what a subtrust is. Did you want to talk about that, Stuart?
Oh, that's more your wheelhouse, but feel free to edify us about subtrusts and how exciting they are.
Well, yeah. Well, for us trust lawyers, we spend a lot of time talking to them. They are exciting for us, but not for everybody else. So when a person creates a trust, usually after they pass away, or if a couple create a trust after they pass away, the trust then has terms to create other trusts. And so we call these other new trusts that are created after somebody dies the subtrust. So I might have a trust for my lifetime, and then after I die, I might create a subtrust for my children. And so then each child would have their own trust. And that's a subtrust of the main trust that I created. And that's why we call it a subtrust. It's just a continuation of the trust, really. But that's the term that lawyers use, or trust lawyers use, to kind of go through that. And then once those are created, they have to be funded with assets. And that's where you get into this negotiation about, well, what assets should go into what subtrusts? What are the value of the assets? Are they equal in value? Because if you're funding two equal trusts and they're supposed to have the same value, but you're putting the properties in on 100% of one property here, 100% of another property there, you have to make sure that they're equal value in terms of what they're valued at. So there's a lot of negotiating and quite frankly, fighting over that sometimes. And so that's how subtrusts, generally work. But I'm not quite sure. You don't normally sell a subtrust, so I don't entirely understand that question. Any thoughts on that, Stuart?
I think you covered it. I mean, I don't understand the question fully either. It just sounds like there's somebody doing something here that the beneficiary has questions about, but I'm not clear on what those are. Perhaps she's talking about selling underlying assets. If a trustee has power to sell underlying assets, they certainly can do that. If there's a reason for them not to do it, there better be a good reason, and perhaps you could get a court to order them not to sell those assets. If they're, some type of unique asset or something that is hard to replace, maybe a judge would be open to instructing the trustee not to sell those assets. But other than that, and then I didn't understand the relationship between the person asking the question and the lawyer. It sounds like they were her lawyer. So, ask your lawyer. If that's your lawyer, just ask exactly what's going on. Repost a question to us, and we'll be happy to take another shot at it.
Yeah, absolutely. And here's the next, question, also kind of an observation on one of our new videos. Our listener writes in and says, was pressured into signing the release. This is in response to one of our videos talking about indemnification clauses and signing releases. They go on to say, as time goes on, I see the fraudulent concealment underlying the demand for the release. I know you guys have kind of touched on this in the past, but maybe you could break down further to kind of lay people like me, what goes into the releases and maybe why you shouldn't sign or kind of what's needed.
Yeah, releases are always dangerous. And so when people talk about release, they're talking about a release of liability. So they want you to sign a document that says that you're not going to turn around and sue the trustee at some later time. And the probate code defines or sets out very specific rules about releases when it comes to trustees, because they're in a power position. They've got all the money, and they're in a position where they can say, well, either you sign this document or I won't give you your money. And we don't want that. The law wants the trustees to do what's right, to make distributions, and to not require releases be signed in exchange for distributions that should be happening anyway under the trust terms and under trust law. And so it's the probate code explicitly says you cannot force a beneficiary to sign a release in exchange for a distribution. And you can actually go to court and have that release set aside if that were to happen. But of course, the better course of action as a beneficiary is don't sign a release. And we've talked before about what's going to happen when you don't sign a release is the trustee probably is going to want to file their accounting in court and get a court order. But that's fine. At least then it requires them to file a full accounting to account for everything they've done. It's going to go through the court process. You'll have an opportunity to take a look at it, do discovery. If you have a lawyer, they can serve subpoenas, take depositions. You can have all the disclosure that you want when it goes through that process. But the problem with just up and signing a release is you're signing away a lot of rights, and you never want to do that in any legal context without being fully informed of what your rights are. What are your thoughts, Stuart?
Yeah, I know. I think you pretty much covered it. I mean, I think that's exactly what's going on here. You don't want to sign it, but if you do sign it, it could be problematic, but it may not be, depending on what the trustee actually disclosed to you, the trustee's lawyer disclosed to you. So maybe perhaps you can get it undone. But yeah, don't ever sign a document just to get a rightful distribution. You're entitled to a rightful distribution. It doesn't mean that the trustee will always make the distributions when they're required. And sometimes you have to hire a lawyer to force that to happen as well. But you don't have to sign away things without first being fully informed about what you're signing away. And part of that is the trustee giving you full transparency as to what they're asking you to waive away from them from a liability standpoint. So better not to sign. If you already signed, but you weren't given much information, you at least have an argument that anything you were not given, any information you were not given, you didn't include in that release.
Yeah, and that's the other thing about a release in the trust context is it only works when you've fully disclosed the material facts to the beneficiaries. So it's a real minefield. I mean, trustees really should not be asking for them except, if you fully disclose, but it happens. And we see a lot of cases where trustees want releases, or they simply refuse to make distributions for any reason or no reason at all. It happens more often than it should.
Okay, here I'll sort of outline the scenario that a listener posed to us and then their kind of question around it. So they say, never received any accounting or asset inventory in almost 2 years. My attorney requested one after a year and it was ignored. Now trust is closing and they want releases / indemnification. How can I agree when I haven't even seen one informal or formal accounting? What are you guys' thoughts on this?
You want to take a crack at that one, Stuart?
Well, again, this is kind of what happened. The last question was somebody signing a release and being upset about it. And that's what this person will probably do as well. And so you want to make sure that you know what you're signing the release for, and you're entitled to an accounting. It doesn't have to be a court filed accounting. It can be a court filed accounting, but it can be an informal accounting. It can be as simple as Excel spreadsheets being passed around if it's a simple enough trust or estate. So get information, get transparency, take a look at it. If it's a smaller estate or a smaller trust, many times the trustee doesn't want to go to the expense of actually filing and a court filed accounting where all the beneficiaries are going to agree to a distribution in any event once everyone sees what happened, how much the trustee's being paid, how much the trustee's lawyer is being paid, how much taxes are being paid. So there's a list of things you'll want to look at and eyeball to determine, is it worth fighting over this? But if it's a $10 million trust and you have a right to call it $3 million of the trust or $5 million of the trust, I wouldn't sign anything without first getting transparency to see exactly what it is that I'm signing away.
Yeah. And so the easy answer to the question of how can I sign it when I haven't gotten full disclosures, you can't. And so don't. And so instead you're going to have to force full disclosure is the bottom line.
Okay. And we'll jump into another topic we had kind of discussed here around the office. I hear, some of Keith's consults and things like that. And this was kind of a topic that we wanted to discuss today because there's a lot of confusion around it, and it's kind of well deserved. So sort of the question or this topic goes around, can I get a trust terminated if it's being held for my lifetime?
Yeah, and that's an excellent question. A lot of people are very confused, and they don't, if a parent passes away and you see a copy of the trust and you thought you were going to get your assets outright, but instead it's being held for your lifetime. And worse yet, maybe you're the only one where it's being held for your lifetime, or the trustee of your trust that's being held for your life is somebody that is not friendly to you, like a sibling or, a family, a friend of your parents who never got along with you. We see a lot of different scenarios where people are kind of locked into these lifetime trusts or trust for a term of years. They have to be a certain age. Trust is going to last for 20, 30 years, whatever it is. And there are ways to go to court and ask the judge to terminate an irrevocable trust. And it's not contesting the trust terms. You're not saying that the trust is invalid in any way. What you're doing is you're going in under very specific probate code sections, 15403, 15409 are the two big ones. And you're asking the court to exercise its discretion to terminate that trust. And it's not a given. The court, you don't have a right to it. The court's not going to just, magically do it for you just because, you are sympathetic. You have to have a reason. And there's all sorts of reasons that go behind this. And it's actually a really big topic. We probably should set aside a whole Ask Two Lawyers just to discuss this topic. But the point that I want to really make to everybody is just because a trust says it's irrevocable doesn't necessarily mean that you have to live under those trust terms for your lifetime. There are ways to seek a termination of that irrevocable trust, but you have to know what you're doing. You have to do it the right way. There's a lot of work that goes into that, but you don't necessarily have to live with that for the rest of your life. And you can imagine if you have an inheritance that's supposed to support you and that's not happening because you have a bad trustee and the whole purpose of the trust is just not working out, there has to be some sort of relief or remedy for that. And there is under the probate code if you know how to do it.
Yeah, it's interesting to me how many people show up to an estate planning lawyer, and it just kind of matters what estate planning lawyer you find, and they have a way of drafting things. And this lawyer, for some reason, has drafted things where they tell and advise their clients, hey, you should hold all this stuff in trust for your children until they're 50 or 60. I've seen them all the way up till 80 years old. There's some that are lifetime and then they go to some remainder person. But you see this and you're thinking, why are you making your child wait till they're 65 or 70 to get their full inheritance? In our experience, if a person is who they're going to be by about age 25, maybe age 30, after that, they are who they are. If they're if they're a good person and a thoughtful person with their expenses and how they spend money and they're efficient and economical, chances are they're going to remain that way. If they're a bit of a spendthrift and they go and burn their money every time they get their hands on it, chances are they're going to do that when they get a hold of the money one way or the other. Many times, it just matters what the settlors really intended. But a lot of times I think they're ending up with lawyers that just draft the trust this way and don't explain it. And the people sign it. And you've got your children who end up in a position where they're not able to access these funds, and they get a paternalistic trustee in there who, doesn't want to work with them. and it causes problems. And so there are ways that we can petition a probate court to see if we can get an outright distribution of those assets that are locked up at the time. It's not easy. It takes some work and some skill, and you're not successful in every case. But in some cases, you can be successful in getting that outright distribution. And in those cases, it's generally worth moving forward with.
I remember a case where this lady, as she got older, she would go in and amend her trust and change the date that everything had to stay in trust for her children. So first it was 35, then 45, then 55, and then 65. It's like, by the time you have adult children who are in their 50s, they are who they are. And so keeping it in trust for another 10 years, you're just causing a whole lot of expense and heartache and frustration, and it's not going to end well. So, at some point, I think you have to just, let it go. But that doesn't, I think you're right. I think there's a lot of people who don't understand what they're signing. And wouldn't you say, if you think about our trust termination cases, the ones where we're going in and terminating, a vast majority of them, the children who have their assets held in trust are perfectly responsible people. It's not, you would think that, this is being done because these are people who have drug problems or financial problems or whatever. And that's true occasionally, but I would say probably 70, 80% of our trust termination cases, they're perfectly responsible adults. They're leading perfectly productive lives. And yet for some reason, there is a trust provision that keeps their share in trust. It is odd. So what do you think, Producer Eric?
Well, I encourage anyone, listening to pose any questions you may have for us. We've talked about a number of cases, going on in pop culture and, I would say maybe politics and economics. We talked about Reggie Bush versus the NCAA and Robbie Robertson, famous musician from the band, and his, estate battle with his wife and kids. And we talked about Tom Girardi and his latest update last week. But if our listeners have anything else, any other topics they'd love us to cover, we'd be excited to hear from you guys.
Who's the guy that owns Fox News?
Murdoch.
Yeah, Murdoch. So Rupert Murdoch. So I just saw an article in the news the other day that Rupert Murdoch lost his bid to change his trust. Did you see that, Stuart?
Based under Nevada law.
Yeah. So and what that tells you, Nevada law, that means it's a dynasty trust. So what super wealthy people do is they create these trusts in these jurisdictions that allow trusts to be in existence forever, in perpetuity, they call it. In California, that doesn't work. At some point, a trust has to end. And in most states, but there's certain states, Nevada, Delaware, where the trust can go on in perpetuity forever. And so apparently he must have Fox News in one of these dynasty trusts, I'm surmising. And as I understand it, it's among his 4 children. So they equally can decide who's going to run Fox News, all 4 of them. But was it 2 or 3 of them are apparently not to his political leaning, and one of them is, and he wanted to make it so that the one child who shares his political beliefs would have control of Fox News and the other 3 wouldn't be able to vote him out or veto him. Was that your understanding of it?
I didn't read the article. I just saw the headline, and I think it was a day or 2 ago. And I just was interested as well that it was a Nevada trust and a Nevada court that's applying. I'm assuming it was a Nevada court that certainly a Nevada law was applied to it. Wouldn't that be interesting if Fox News ended up in control of 2 of the 4 children that were more liberal than Rupert Murdoch? I mean, what happens to the programming on Fox News? I'm not commenting on whether it's good or bad that Fox News is conservative leaning. MSNBC is up for sale right now, and I think there's questions about what will happen to MSNBC, which has been a very left-leaning news source once it's sold. Are the same talking heads going to be on there? Are the same shows going to be on there? So we're seeing a huge shift in the way that people get news. I think Elon Musk may be the one that runs off to the bank with his 400 billion plus in earnings right now, or wealth right now, because he bought Twitter, and he bought it at a time where everybody kind of made fun of him for it. But more and more people are getting their news from places like Twitter, or I guess it's called X now. And they're not using traditional media. And so that happened with newspapers, years ago. And there's now just a few newspapers that really matter. The Washington Post, which is owned by Jeff Bezos. So those media, I think the LA Times has been hurting for years. New York Times has been hurting. And so what happens when Fox News transfers hands? And I think Rupert Murdoch isn't he in his 90s? I mean, he's not young, and not to say that he's sick or anything, but somebody that's in their 90s, it could be the wrong wind blowing on them on a certain day, and that's it. And that's true of all of us. It's not just Rupert Murdoch. So interesting that he wasn't able to make the change that he wanted to make, and that also lets you know that there's maybe perhaps some cognitive issues that the court was looking at. I don't know if it was just the terms of the trust, Keith, or if it had to do with his abilities to function from a mental standpoint. But whatever the reason, he's not allowed to do it according to Nevada law.
Yeah, and these dynasty trusts are irrevocable trusts, so it's not like a typical revocable trust where you can just go in and amend it. That's probably why they were trying to go in and get court approval. But yeah, it's very interesting. I mean, if there's only one child who, would run Fox News the way Murdoch would, and 3 who wouldn't. And most people are, when they're doing their estate planning, they're worried about what am I going to do with my house? What am I going to do with my 401k? He's got to worry about what am I going to do with Fox News? And so it's a really interesting issue and an interesting case. And since I brought it up, we'll monitor it. So I'll see if there's any further updates and see if anything changes on that front. But I just thought it was interesting. It's not every day that somebody has to worry about, a news station as to how it's going to go in terms of inheritance. So
Right.
Yeah, we'll keep an eye on that. I'll keep you guys updated if I see any new, stories or headlines around it too. Elon Musk net worth increased by 77% since November.
Wow.
Just yeah, I'm not saying it's good or bad.
Well, it's good for
That's
him.
what it is. Yeah. Yeah.
I mean, he needed more money.
Yeah, over 400 billion now.
I can't even understand that. I can't even comprehend. I mean, if somebody has 400 million, I'm like, that's an amazing amount of money. 400 billion, it's hard to even comprehend that number.
I couldn't quite do the math the other day, but somebody said if he gave away $1 billion to everybody in the U.S. from a population standpoint, he'd still have 50 billion left over or something like that. So,
well, that sounds like a good plan to me. He should do that.
Yeah, he'd make all Americans rich, and then we'd all take our money and we'd, of course, spend it in the rest of the world. It'd be good for everybody. So, Mr. Musk, if you're listening, I think it's just a scientific experiment. If you wouldn't mind dropping off about $1 billion to every person in the U.S., that would be fantastic.
Yeah, that'd be great. Let's see if it works.
Talk about inflation. What happens to products in the U.S. if everybody has $1 billion? Wow.
Yeah, that'd be a problem. Bread would cost like $1 million per loaf or something. Yeah, it'd be crazy. Well, I want to thank everybody for tuning in to Ask Two Lawyers today. As always, subscribe to our channel and hit the notification button so that you can be notified when we're going to go live. And we encourage you to leave comments on any of our videos. We do monitor the comments on this video once we're done being live and it goes on as a video, or any of our other videos in our video library. And we will answer those questions on our next Ask Two Lawyers. Thank you very much, Producer Eric.
You're welcome. And yeah, we see everything. So leave us a question anywhere and we will answer it next week. Subscribe to the channel if you haven't already too. We're about 50 away from breaking 4,000. So we're super thankful for everyone who subscribes and watches the content. And yeah, I wanted to get that done by the end of the year. So we'll see if we can make that happen.
That'd be nice. That'd be a good Christmas present.
Yeah.
Any final thoughts, Stuart?
No, just wish everybody well. And during this holiday season, I hope everyone's getting their Christmas shopping done. And we'll see you back here next Friday, 1 p.m. Pacific time. And please bring your trust and estate questions or any other legal questions you have. We'll take a shot at those too. We may not be as good at those, but we're happy to see if we can get somebody in the ballpark if they have a question that's outside of our expertise.
Yeah, absolutely. Well, have a great Friday, everybody, and a great weekend. We'll see you next week.